I'm Richie Epping. This is Chapter 5, where we're going to focus on advocacy skills. So effective advocacy is a learned skill. We can all learn it. And its fundamentals are understanding the subject matter, careful preparation and analysis, and planning out very carefully the presentation that you're going to make so that you can convince somebody. It's fundamentally about persuading other people, but because in this case we're doing this on behalf of our client, you have to start with the client and what the client wants and what the client needs. Any of us can learn how to do these things if we focus on them. So knowing the subject matter. Medicaid is complicated. We don't have to know everything about Medicaid, fortunately, for the purpose of doing these appeals. But you should spend some time focusing on the rules and circumstances that surround the DD program. You'll always need to know very familiarly your client, the services that they need, the services that they want, the rules that govern the specific Medicaid DD program and the DD waiver program, and the record. By the record, we're talking about all of the documents that we've talked about in Chapter 3, the budget notice, and all of the other things that you've gathered together in your appeal packet. You'll want to know all four of those things extremely well in order to be an effective advocate. So knowing the subject matter. The client, of course, is your client who's an adult in the DD program, and throughout this program, the decision-making capacities is highly varied. Every single adult in this program is different, and we have to respect that and understand their desire and ability to participate throughout the appeal process and all of the other reviews that are available. The adult that you represent is different than their guardian. Don't assume and don't take what the guardian says to be the answer to any question about your client. Ultimately, your client gets to make that decision unless they are unable to make that decision themselves. Your client is also different than their providers. What the providers want is not always going to be the same as what your client wants, and you are representing your client, and your client ultimately makes that final decision. Throughout this process, you should be and need to be respecting the autonomy, the self-determination of your client, and promoting that adult's maximum integration into the community that we all share. Knowing the program and the rules. There are several different programs, so to speak, within the adult DD service program. One of them is called the State Plan Program. And there aren't too many people who are just in the State Plan Program, but you may have someone who is just in the State Plan Program. Many people are either in the waiver or the self-directed program, which are essentially the same thing, but they're different pathways through the Medicaid program for adults with developmental and intellectual disabilities. You'll want to know all of the available services, which are slightly different depending on whether you're in the state plan, the waiver, or the self-directed program. You'll want to know the eligibility criteria for these programs and what the Department of Health and Welfare calls the prior authorization rules. These are the rules that they follow to determine whether or not someone's service plan or support plan will be approved. And of course, as we've covered in previous chapters, you'll want to understand the health and safety criteria, which the department now uses to determine whether someone can go above their budget, even if that budget was calculated correctly by the budget tool. Knowing the record. So that record is this appeal packet that you should have prepared and be adding to as you prepare for informal review and for hearing. You'll want to know at the top of your head what you're able to prove with the witnesses and the documents that you've been able to assemble. And if there's something that's important to prove that you haven't identified yet, you'll have to try to figure out where you can get that information. You want to know what's in your client's medical records. You want to know what witnesses are available, what people, healthcare providers, care providers of other sorts, family members, what witnesses are available and what they'll say if you go to hearing. You want to know what documents have been submitted either in the past or this year if you're in extended informal review to support the plan of services that your client wants, that a particular adult wants. You'll want to understand what the basis for any denials have been, whether it's denial of a plan or if you go through the informal review process and the informal review was denied, the department should be giving you a written explanation of the reasons why it denied that informal review. You want to understand what that basis was so that you can go into the hearing prepared. And you'll want to know, of course, what all of the assessment tools said, and not only what they said, but whether or not they're accurate and correct. Planning out your case involves extensive preparation. It involves outlining what you're going to present at an appeal hearing especially, and then practicing before you appear at the appeal hearing, whether it's by phone or in person. You want to practice that before you get there. Outlining your case. If you're going to a fair hearing before a hearing officer, there are several components to how these sorts of cases are presented, and they're based basically on how lawyers present cases in court. There is an open opportunity for an opening statement. It's where you get to summarize the information that you're going to be providing during the hearing. You're going to interview, essentially examine witnesses during that hearing, and so you want to outline what you're going to ask each of them. You want to know what documents you're going to use. We call these exhibits so that we can refer to them during the hearing. You want to know what those documents are going to be, and then at the end of the hearing you'll have an opportunity to make a closing statement that sort of makes your argument, makes your best case for why all this evidence means that the hearing officer should rule in your favor. As part of outlining your case, you need to understand the laws and the rules that are applicable to your client and throughout the DD program itself. Outlining witnesses. So there's two types of ways that you could ask questions to a witness, what we call examine a witness. One of them is called direct examination, and that's what you do when you have called that witness. So let's say you want to ask a family member to talk about your client and their abilities to show, for instance, maybe that an assessment was done incorrectly. In that case, you will ask them questions that don't assume an answer, and so you'll want to be very careful to know what questions are going to prompt them to say what in response. So you won't be able to say to them, hey, I want you to confirm that this is the truth. You'll have to ask them a question about what are your son's abilities when it comes to feeding himself. And they get to tell a story about what the answer to that is. So to do that effectively, you have to have an outline going into it. And you'll want to have practiced that outline with the family member or the witness that you're going to be talking to. So here's an example of the beginning of a witness outline on this slide. You'll want to ask them their name, ask them who they are. If they're a professional, you want to ask them what their title is. If a family member, what their role is. They live with your client or they don't. And what their relevant background is so the hearing officer can understand why this person is somebody to trust when it comes to the client that you have. Then, for each thing that you want to establish with this witness, you'll want to write out some questions that are going to prompt them to give you the answers that will prove your case. So, what have you observed? What interventions have you tried? What worked? These kinds of questions that don't assume the answer, but allow your witness to tell the story that will help persuade the hearing officer. So when the department calls a witness at the hearing, you'll get to do what's called cross-examination. This is one of the most effective ways of advocating for a client and proving your case. And when you do cross-examination, when you're asking questions to the department's witness, might be an assessor or a care manager at the department, you can assume the answer and get them to confirm something that you think that you already know. You don't have to ask questions like, what have you observed? You can say, you knew that this respondent didn't know and had never observed this person feeding themselves, didn't you? You knew that there was also this medical doctor that had information about this person's disability and you didn't consult with them, did you? Those are examples of what are called leading questions, and that is a very effective way for you to get information out of somebody who may be reluctant to give it to you otherwise. The trick to cross-examination is always asking questions that you already know the answer to and that you're fairly certain that the person is not going to dispute. So you can, for each person that you think that the department is going to use during hearing, and you'll get a list of their witnesses before the hearing, you can make a list of things that you think that they definitely will admit that help your case, and just state those essentially as statements during your cross-examination and ask them to confirm that that's the case. That's what is called cross-examination, and you should definitely be using cross-examination and leading questions when you're asking questions at a hearing of the department's own witnesses.